Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company, and the topic for today's second video presentation is the arbitration agreement under the Arbitration Act. So under this part, arbitration agreement means an agreement by the parties to submit to arbitration or certain disputes which have arisen or which may arise between them in respect of defined legal relationship. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration agreement shall be in writing. Further, an arbitration agreement is in writing if it is contained in first provision, which is a document signed by the parties. Second, an exchange of letters, telegrams, etc. An exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other party. The reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is in such as to make the arbitration clause part of the contract. Section 7 clause 1 talks about the three elements, which is defined legal relationship, disputes which have arisen or may arise, and third, whether contractual or not. The various essentials or attributes of a valid arbitration agreement were given under the famous landmark judgment of K.K. Modi versus K.N. Modi, which states that the arbitration agreement must contemplate that the decision of the tribunal will be binding on the parties to the agreement. Second, that the jurisdiction of the tribunal to decide the rights of the parties must be derived either from the consent of the parties or from an order of the court or from a statute, the terms of which make it clear that the process is to be an arbitration. Third, the agreement must contemplate that substantive rights of parties will be determined by the agreed tribunal. And fourth, that the tribunal will determine the rights of the parties in an impartial and judicial manner, with the tribunal owning an equal obligation of fairness towards both the sides. Fifth one is that the agreement of the parties to refer their disputes to the decision of the tribunal must be intended to be enforceable in law. And lastly, the last condition was that the agreement must contemplate that the tribunal will make a decision upon a dispute which is already formulated at the time when the reference has been made in the tribunal. Further, it was added that the parties should agree that the decision of the tribunal shall be binding on them. Section 7 clause 2 talks about the arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. The concept of doctrine of separability is quite an important concept under this, which states that it provides that an arbitration clause embedded in a contract is considered separate from the main contract. This doctrine was first formulated in France in 1963 in the Cosset judgment, and since then it has been widely acknowledged. Another landmark case of V Network Limited versus Econet Wireless International Limited, in which agreement to arbitrate would not be rendered void or invalid solely because the principal contract was void or invalid. And last landmark case under this is the Premium Nafta Products Limited versus Philly Shipping Company Limited. The principle of separability means the invalidity or rescission of the main contract does not necessarily entail the invalidity or rescission of the arbitration agreement. The arbitration agreement must be treated as a distinct agreement and can be void or voidable only on the grounds which relate directly to the arbitration agreement. So these were some of the important points and topics and landmark judgments under the concept of arbitration agreement under the Arbitration Act, and I hope you get a basic idea of the topic. Thank you.